In the trial, the state has another opportunity to address what we feel our theory of the case is and how we feel we have proved the case to you. This is not a surprise. This is not a special circumstance in this case. This is a part of the argument that we get to do in every single case. And we often leave this time to address the issues that the defense feels are the weaknesses in our case. However, as I stand before you here today representing the state in this matter, in the case against Elizabeth Johnson, where she is charged with 3 counts, I am confident that we have proven every element to you of every crime beyond a reasonable doubt. Now, we've heard from defense counsel already where he essentially conceded count 2. And count 3, he essentially concedes as well. He's focused the most of his arguments on the kidnapping charge. What I'm going to do at this time is fast forward through my presentation to the custodial interference count. Custodial interference, we have to prove that between December 18th, 2009 and December 26th, 2009, Elizabeth Johnson took, enticed, or kept from lawful custody any child entrusted by authority of law to the custody of another person. In this case, the child entrusted by authority of law is Gabriel Johnson. To the custody of another person is Logan McQuarrie. And that Elizabeth Johnson knew or had reason to know she had no legal right to do so. You saw the custody hearing which she attended. It was very clear what the orders of the court were. It was made very clear to both parties what was to happen. She was to turn him over on December 20th for his visitation and every other Sunday after that through Wednesday. The court also ordered that Logan McQuarrie was to have the custody of his child on Christmas Eve. But this has been conceded by the defense. Count 3 is the conspiracy to commit custodial interference. And what we need to prove is that between December 18th, 2009 and December 26th, 2009, that there existed a conspiracy between Elizabeth Johnson and another person to commit the offense of custodial interference. We don't have to actually prove that the custodial interference occurred. We just have to prove that there was an agreement between two or more people that they would engage in committing this crime. We have to prove that Elizabeth Johnson agreed with one or more persons that one of them would engage in certain conduct, that Elizabeth Johnson intended to promote or assist in the commission of such conduct, that the intended conduct would constitute a crime, and that an overt act was committed in the furtherance of such conduct. Now, in this case, we have submitted to you that she conspired with Tammy Smith to commit custodial interference against Logan McQuarrie. And I think the evidence here is very clear. We do not have to prove, as is stated in your jury instructions, that there was a written agreement, that they tape recorded their agreement, that they agreed on an exact plan. What we do have to show you, though, is that there was a plan, that there was an agreed course of conduct between these two parties to engage in activities that would constitute custodial interference. The evidence in this case is quite clear that there was a lot of manipulation going on. There was a lot of manipulation by Tammy Smith, and there was an equal amount of manipulation by Elizabeth Johnson. So to suggest that one person was controlling this over the other is incorrect. They were both manipulating the situation for their own desires. It is our theory of the case, and has been from the beginning, that Elizabeth Johnson's motive in committing all of these crimes was to keep Gabriel Johnson from Logan McQuarrie in an effort to retaliate against him. It is conceded by the defense that Tammy Smith wanted a baby. She wanted Gabriel Johnson, and she was going to get him at all costs. Now, there is clear evidence in this case that there was a plan between the two. It's acknowledged in the KPHO recording. There's evidence of it in the false document that they filed with the court on December 14th. They clearly conspired together to interfere with Logan's custodial rights. Now, on the 14th, that could not have been a crime at that time because he did not have custodial rights until the 17th. However, that act on the 14th is evidence of the fact that they were working together. Defense agrees they were working together. However, he disagrees at what point they stopped working together. In this case, it is clear that there was a point at which Elizabeth Johnson went rogue. She went off the course of the plan. It's never been the state's position that Tammy Smith enticed her to go to the state of Texas. The state is fully cognizant of the fact that Elizabeth Johnson made that decision on her own. However, once Elizabeth Johnson did go to the state of Texas on December 18th, 2009, the conspiracy did not stop there. Because you heard evidence from Deanna Ayala, who clearly stated that after Elizabeth Johnson left the state of Arizona, Tammy Smith told her that it was their plan at that point to change jurisdictions to the state of Tennessee. Deanna Ayala told you, she was Tammy Smith's friend at the time, that these two had a plan to interfere with Logan's rights, and initially started that they were going to frustrate him with placing other men on the custody documents to frustrate the DNA process. It then changed. There's nowhere in the law that says their plan can't change. Now, one person can decide to do something different that the other didn't agree on. In this case, Elizabeth Johnson left the state of Arizona and went to Texas. But once she left there, they continued their conspiracy. And the evidence of that is apparent from Deanna Ayala's testimony. It's also apparent from the text messages that Tammy Smith sent to Elizabeth Johnson regarding contacting her friend in Tennessee. You saw the text messages where Tammy Smith asked another friend for Janet Morris's phone number because she knows a good adoption attorney in Tennessee. And this is at a point in which she clearly knows that Logan McQuarrie is not agreeing to adopt this child any longer, and yet she's continuing to seek that adoption. She's continuing to speak to Elizabeth about it, text her about it. Elizabeth calls that person Janet Morris. Elizabeth obviously puts Tennessee into her GPS. Whether she went there or not is we can't prove. But it was a part of the plan at that point. And it's the state's position that once they found out they couldn't do it anymore, yes, then they gave up on that plan. That is an overt act. Defense says that the only overt act we could show you in this case to prove a conspiracy would be that Tammy Smith set up the meeting with the couple in Texas. That is not our theory. That is not what we are presenting to you as to what the overt act was. Because quite frankly, we have no evidence to support that Tammy Smith, in fact, set up a meeting with a couple in San Antonio. But what we do have evidence to is that she wanted to change jurisdictions, and that as late as December 22nd, 2009, she was continuing to try to get Logan McQuarrie to sign adoption paperwork. She tells him on a phone call, and she tells him in a text. Now, an interesting thing in the realm of conspiracy, in your jury instructions, is that it states that the members of the conspiracy do not need to necessarily know what the acts of all the other conspirators are. It's on page 7. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. However, they have to agree on what the conspiracy is, and it's clear here that there was an agreement to interfere with Logan's custodial rights. And Tammy Smith committed that overt act. Now, with regard to kidnapping, what the state must prove is between December 18th, 2009 and December 30th, 2009, Elizabeth Johnson knowingly restrained Gabriel Johnson with the intent to place Logan McQuarrie in reasonable apprehension of imminent physical injury to Gabriel Johnson. Now, I've broken this down into essentially two elements for you. Part one is that she must restrain Gabriel Johnson. In your jury instructions, there is a definition of restrain. Restrain means to restrict a person's movements without consent, without legal authority, and in a manner that substantially interferes with a person's liberty by either 1, moving such person from place to place, or 2, by confining such person. Defense's theory of the case is that there is no restraint in this case. And he says that for 2 reasons. First, he cites to you that there's no restraint because she was not physically holding on to Gabriel Johnson, that this isn't physically restrained. Where in this definition does it state that? That is not a requirement. Of what we have to show for restraint. Restraint here is restricting a person's movements without consent, and in this case, consent. Without consent means if the victim is a child less than 18 and has acquiesced, which means they've just gone along with their parent, and clearly we have a 7-month-old child here who can't do anything but acquiesce to his mother's movements, and the victim's lawful custodian has not acquiesced in the movement. She moved him from the state of Arizona to the state of Texas without Logan McQuarrie's consent or acquiescence. He did not agree to that on the 18th. He did not agree to it on the 19th. He did not agree to her staying there on the 20th. She was restraining Gabriel Johnson during that time. She moved him from place to place, and it's our assertion that she confined him in the state of Texas without legal authority, without Logan McQuarrie's consent, and in a manner that substantially interferes with such person's liberty. She was interfering with her child's liberty to be with his father, which was ordered by the court, his liberty to be raised by his father, to have visitation with his father. In addition, defense argues that the restraint must occur at the same time. Well, I'll get to that argument after. I'll address that argument in a moment. But the bottom line here is that his third prong of his reasons why we haven't proved kidnapping, that there is no restraint, is simply untrue. Looking at the definition here, there clearly was a restraint in this case. Part 2 of kidnapping is that she must have an intent to commit some further act. And the act that we have alleged here is that she acted with the intent to place Logan McQuarrie in reasonable apprehension of imminent physical injury to Gabriel Johnson. Now, ladies and gentlemen, defense also, their number one theory here is that with this prong of the element is that we have not shown imminent proof that she wanted to place him in reasonable apprehension of imminent physical injury. Well, ladies and gentlemen, they just want to look at what occurred on December 27th. They just want to look at what occurred that day. But life doesn't occur in a vacuum, and this case did not occur in a vacuum. And there's substantial evidence that we have presented dating back from from June of 2009 all the way to December 30th of 2009 that she intended to place him in reasonable apprehension of physical injury to Gabriel Johnson. Defense chastised us for showing you all the lies and inconsistencies that Elizabeth Johnson has made throughout the evidence presented in this case, and stated that there's really no purpose for that. That is not true. Because, ladies and gentlemen, Elizabeth Johnson knows she lies. She knows that when she's making false police reports about the child being kidnapped and knowing where the child is the whole time, she knows that's a lie. She knows Logan McQuarrie knows that's a lie. She knows Logan McQuarrie knows about all the manipulations that she has gone on through their relationship. She knows that Logan McQuarrie is aware of the fact that she often states things that are untrue in order to get back at him. Him more details, more details, more details, more details. She knows that he knows she's a manipulator. Evidence of intent in this case. There are previous acts to the date of the 27th that show her intent and common plan. In June 2009, she takes off to Boston with Gabriel, doesn't tell him where they're going until a couple days later, and then decides to divulge she's in Boston visiting her grandma with the child. September 2009, she accuses Frank McQuarrie of kidnapping. A lie. Logan knows it's a lie, she knows it's a lie. On December 8th, she accuses Logan of kidnapping after she told him to take the child. She knows it's a lie, he knows it's a lie. On December 9th, she accuses Logan of kidnapping again, knowing that the child is with the Smiths. On December 18th, she tells him on the phone, "You're never going to see him again." And she has no contact with him during the time period of the 18th until the 26th via phone. She does send him a message on MySpace during that time. However, there is no telephone contact. He has no idea where she's gone during that time. He's gone to the police. Certainly, those actions alone, taken all together, would cause a third person to fear for the safety of their child. Then you come to the 27th. She makes threats of harm to Gabriel. She says, "I killed him, I stuffed him in the bag, I put him in the dumpster." They have a phone call. She describes it more in detail. However, what's key is that she texts him as well, and you can spend the rest of your pathetic life worrying about him. She knows and she intends by her words for him to be in apprehension of physical harm to his child. Just because she says it's in the past does not mean she did not intend to put him in fear for safety of that child. We've all been in relationships with other people, and we know what buttons to press. We know what will make them upset. We know what will make them angry. We know what will make them sad. We know what will make them fear something, and that's exactly what she did. That was her intent, and that's what she did. She then tells Tammy later that day, "I texted Logan that to hurt him and mess with him to get back at him." Clear evidence of her intent to mess with him and get back at him. December 29th, another message to Tammy on MySpace. "I wanted him to hurt like he hurt me." Ladies and gentlemen, the defense also attacks that...
Judge, we have an objection. Could we approach, please?
No, there's not an objection in the last sequence that I would sustain.
Well, Judge, we think that something was said that misstates what the evidence is.
can approach.
There appears to be a discrepancy in, you could spend the rest of your pathetic life worrying about him. It may state wondering in the actual text message, and if that's what it states, then obviously you as the jury decide that that's what it states. Nonetheless, the intent that she's relaying to him at that time is you can spend the rest of your life wondering where he is, wondering what's happened to him, wondering what I've done to him, or what I'm going to do. Defense also attacks that there's a concurrency problem in this case, that the restraint must meet with the intent. And while this is correct, there has to be her restraining him at some point while she intends to commit these acts against Logan McQuarrie. There's no requirement that the intent be at the inception of the restraint, at the end of the restraint, in the middle of the restraint, just at some point. At some point, she had to have been restraining him. And that does not mean physical restraint by holding him. She can abandon the child and its restraint. She can give the child to somebody else and its restraint, because that movement was not agreed to by Logan McQuarrie. And there's no requirement in the statute that she physically have to have the child at the moment that she makes those statements to cause reasonable apprehension of imminent physical injury to Gabriel Johnson. There's nowhere in the statute that says that. Defense states that because on the 27th, there's no evidence that she had possession of Gabriel Johnson, that our crime ends there. That is contrary to what the law states. Nowhere in that instruction does it state that she has to possess the child at the time. She just has to have restrained him. And think about it. You could have a stranger abducting a child and giving them away to someone else, and that's still kidnapping. It's no different here. Just because she physically didn't have him with her at the bus station or on the bus doesn't mean she wasn't restraining him at that time. And it's the state's position, yes, that she's continued to restrain him through the 30th, because she moved that child and confined him in violation of the law. Defense points that there's every evidence in this case to the contrary, that she cared for Gabriel, that she loved Gabriel. We don't have to prove that she was a good mother or a bad mother. Defense is right about that. What we have to prove is what she did with that child during that time period was against the law, and we have shown that to you. At the end of the day, ladies and gentlemen, there's a big picture here with all three of the counts. The big picture is that Elizabeth Johnson acted, and she had two goals in mind. Number one, she wanted to keep Gabriel from Logan McQuarrie, and she accomplished that. We've proven to you that she did commit custodial interference and that there was a conspiracy to commit custodial interference. Second, she acted in retaliation. She wanted to hurt Logan by making him reasonably afraid or reasonably worried about the physical safety of his son. And she acted in a manner which did that. At the end of the day, ladies and gentlemen, the big picture is that this is a case about a woman scorned who would go to any lengths, even using her son, even using her child, against Logan McQuarrie, to retaliate against him and seek vengeance on him. And that's what she did, ladies and gentlemen. And we ask and tell you that the evidence in this case is clear and that there is no other verdict but guilty as charged on all counts. Thank you.
Thank you, Mr. Romano. Okay, we are now at my least favorite part of the trial, and let me tell you why. The reason is we're about to finalize the instructions, meaning I'm going to read you the last page in a moment. And the last page contemplates that 12 of you will go back and deliberate. Well, there are currently 15 of you. And what that means is we've got to select 3 alternates. In other words, 3 of you who have sat here for literally weeks, many hours of focusing on the evidence, giving up job obligations, family obligations, school obligations, will now be told, thank you for sitting here for so long, but now you don't get to deliberate and you have to go home. That is a lousy result, and I wish there's a way I could fix that. In civil cases, there is actually a way you can fix it. I used to be a civil trial lawyer, and then my first assignment was as a civil judge. In civil cases, the lawyers can agree that the alternates can also deliberate, and in civil cases, the jury does not have to be unanimous, so you can agree on a split. In other words, typically it's 8 jurors in a civil case, and it's usually you need 6 for a verdict. If you let 1 or 2 alternates deliberate, you can agree that maybe 7 out of 10 or 7 out of 9. Here, we don't have that flexibility. The jury has to be unanimous, and even if the lawyers wanted to, they can't agree to let you all deliberate. It has to only be 12 of you. Now, we picked 15 because it's quite possible during a long trial we may lose someone. Statistics say we should have lost some of you, but you guys are so diligent and committed we didn't lose any of you, which means we now have to pick 3 numbers of jurors who are going to be designated as alternates. A couple things before we pick the numbers. Number 1, first and foremost, for those that get picked, I'm sorry. I don't know who you're going to be, but I'm sorry, because it is hard to be here and then to be asked to go home. And that's just a difficulty that we can't get around. 2, the admonition is still going to be in effect, because once we select the 3 alternates, and the first alternate we select will be alternate number 1, then 2, then 3, if one of the 12 deliberating jurors has an issue during deliberations and can't continue, family emergency, they get sick, what happens is we then bring in the first alternate and the jury's instructed to start over again with that alternate. So there's 12 starting from scratch. Now you may think, well, that's never going to happen. It does. It's happened to me about 8 to 10 trials ago. We lost a juror during deliberation, and we had to call one of our alternates back. So because that possibility exists, we need the alternates to continue to follow the admonition so that you can deliberate if you're called back. What we will do is once the jury has reached a verdict, if you're an alternate, while you're sitting there wondering what's going on and you can't pay attention to media coverage, don't worry, we'll call you as soon as the jury comes back to let you know that the admonition's lifted and you can talk about the case. But until then, if you're one of the alternates, you get the worst of both worlds. You can't deliberate, and you have to continue to follow the admonition. So you get it coming and going. I wish there was something I could do about it, but I can't. So what we're going to do, Eileen's got that can right there that's got numbers in it. You all know that you have numbers. We start with juror number 1 in the back row to 7, and then 8 to 15. So if your number's called, you're going to be the alternate. If you are called, you leave your notebook on your chair when you go. We'll make sure, Kim will make sure that we have your contact information, your phone number. She'll need to get a good phone number for you. And then we'll release you and we'll wait for the verdict to come back. So without further ado, Eileen, go ahead and pick the numbers of the jurors who are going to be our alternates. The first alternate number 1 is going to be?
Juror number 5.
Juror number 5 is our first alternate.
Juror number 8.
Juror number 8 is our second alternate. And finally,
Juror number 9.
juror number 9 is our third alternate. Let me say again, I'm sorry you guys are the alternates and you can't deliberate. I wish there was something else I could say, but there's not. So what we're going to have you do is leave your notebooks there. Follow Kim out. She'll get your contact information. Thank you so much for serving as jurors on this case. I really appreciate it. I know how difficult it is, and we appreciate you being here. So, Kim, go ahead and bring them out. Thank you again. Okay. So for the 12 remaining jurors, now I'm going to read the last page of the instructions to you, and we're going to talk about some of the nuts and bolts of the verdict forms. So here we go. The case is now submitted to you for decision. When you go to the jury room, you will choose a foreperson. He or she will preside over your deliberations. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set it and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the bailiff. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the written jury instructions and verdict forms. It may be helpful for you to discuss the instructions and verdict forms to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you've reached a verdict or verdicts or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, MySpace, LinkedIn, YouTube, or Twitter, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on each verdict. In other words, you must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked foreperson. You will be given 4 forms of verdict. The verdict forms read as follows, and there is no significance to the order in which the options of guilty, not guilty are listed on the verdict forms. So I have the verdict forms right here, and they're going to go back with you in an envelope, and let me read to you the verdict forms. You actually have 2 verdicts that relate to count 1, kidnapping, and then a single verdict form that relates to count 2 and a single one that relates to count 3. Let's start with the first one. It says verdict count 1. It's got the caption of the case on it. It says, we the jury duly impaneled and sworn in the above entitled action upon our oaths do find the defendant, Elizabeth Johnson, as to the offense of kidnapping, not guilty or guilty. You check 1. If you check not guilty, you're finished with this form. If you check not guilty. If you check guilty, then there are 2 more questions for you to answer on this particular form. And it tells you this. It says if you find the defendant guilty of kidnapping, you must decide, and then there are 2 questions. Number 1, was the victim released voluntarily by the defendant without physical injury in a safe place before arrest and before placing Logan McQuarrie in reasonable apprehension of imminent physical injury to Gabriel Johnson, yes or no? You answer, you check either yes or no, and then you go on to a second question that says, if you find the defendant guilty of kidnapping, complete the following, choose only one. We further find that this offense is a domestic violence offense. We further find that this offense is not a domestic violence offense. There is a definition of domestic violence in the jury instructions that you can utilize, along with the evidence. So that's the first form, verdict count 1. Now the second form also relates to count 1, and it says in parentheses, lesser included. Your instructions included an explanation about lesser included offenses. And what it told you is that the offense of unlawful imprisonment is what's called a lesser included offense of kidnapping. So, if, and only if, you find the defendant either not guilty of kidnapping or you cannot reach a verdict on kidnapping, you can then consider the verdict count 1 for lesser included. In other words, if you find the defendant guilty of count 1, you don't even fill out this lesser included form. It's only not guilty, or if you can't reach a verdict on the kidnapping count. Again, your instructions explain this to you. So if it's a not guilty verdict, or you can't reach a verdict, you get to this. And it says, having found the defendant not guilty of kidnapping, or, after full and careful consideration of the facts, being unable to agree on whether to find the defendant guilty or not guilty of kidnapping, we, the jury, duly impaneled and sworn in the above entitled action upon our oaths to find the defendant, Elizabeth Johnson, as to the offense of unlawful imprisonment, not guilty, guilty. You check 1. If you check not guilty, you're done with this form. But just like the first form, if you've gotten to this one and you check guilty, then you have 2 more questions to answer. The first question is, if you find the defendant guilty of unlawful imprisonment, complete the following. We further find that this offense is a domestic violence offense, or we further find that this offense is not a domestic violence offense. You check 1 of those. Second question, if you find the defendant guilty of unlawful imprisonment, you must decide, was the victim released voluntarily by the defendant without physical injury in a safe place prior to arrest, yes or no? So that's the first 2 forms, and those relate to count 1. Then for counts 2 and 3, there are single verdict forms. For count 2, which is the conspiracy to commit custodial interference count, the same caption, the same lead-in, and it asked, as to the offense of conspiracy to commit custodial interference, not guilty or guilty. If you check not guilty, again, you're done with this form. If it's guilty, then you go on, and this time you have 3 more questions to answer, and it's right here on the verdict form. If you find the defendant guilty of conspiracy to commit custodial interference, complete the following. Choose only 1. The defendant was the child's parent, or the defendant was not the child's parent. You check 1 of the boxes. Second question, choose only 1. The child was taken, enticed, or kept out of state, or the child was not taken, enticed, or kept out of state. You check 1. Then the third question is, choosing only 1, the child was voluntarily returned without physical injury prior to arrest or the issuance of an arrest warrant, or the child was not voluntarily returned without physical injury prior to arrest or the issuance of an arrest warrant, and you check 1 of the boxes. So that's count 2. Finally, I'm sorry, there's a 4th question I forgot, as to count 2, if you find the defendant guilty, and that is, we further find that this is a domestic violence offense. We further find that this offense is not a domestic violence offense. So you have 4 follow-up questions as to count 2. Finally, as to count 3, again, the same caption. We, the jury, duly impaneled and sworn in the above entitled action upon our oath, do find the defendant, Elizabeth Johnson, as to the offense of custodial interference, not guilty, guilty. Check not guilty, you're done with this form. Guilty, you will go on and have the exact same 4 questions that you would have with the conspiracy to commit custodial interference. So those are the 4 forms that you will have going back to fill out. Now, a couple more things about the process and the procedure. In a moment, we're going to swear Kim in, and she's going to take you back to the jury room to deliberate. A couple things I want to emphasize. You can only deliberate when everyone is together in the jury room. Somebody can't step out to the restroom and then everybody continues to deliberate. It has to be when all of you are present. You have now spent the last however many weeks being prisoners to the court schedule. You are now about to set your own schedule for deliberation. So you can decide by agreement to continue to keep the same hours we've been keeping, 10:30 until noon, 1:30 to 4:30 or 4:45, or by unanimous agreement, you can set other hours. The only parameters are you can't start before 8:30 and you must end by 5 o'clock. But you can take lunch when you want. You can do it any way you want. You just need to agree, number 1, and number 2, let us know when you're leaving. Kim's going to give you the contact information where you can call her when you're all leaving. We need to know when you're deliberating, when you're not. Otherwise, you decide. I find it highly unlikely that you'll get anything done today. I'm assuming you'll come back tomorrow. What I'd like you to do once you go back is just let Kim know what time you're coming back tomorrow, and then we'll know when you're coming. Whenever you come back with your verdicts, will be here for you. There's always a delay of a little while so we can get everybody in the courtroom once there's a verdict. If it takes you till tomorrow, the next day, or sometime thereafter, that's up to you. There is no time limit on your deliberation going forward. So that's how we're going to do it. You can bring your notebooks, obviously, back with you. They have to stay in the room, of course. And all of the exhibits that have been admitted to evidence will be brought back to you. We will also make, starting tomorrow, a laptop available to you if you want to play anything that you saw that was played for you that's in evidence. You can play. We'll provide to you a laptop, and if it doesn't work, we'll provide the necessary technical support to make it work. All right, so that's what we're going to do. Let's go ahead and swear Kim in.
Do you swear that you'll take charge of this jury, protect their deliberations from all outside interference, and communicate?
You want to take the verdict forms? Okay. Good luck. We'll see you when you have verdicts.
All right.
Okay, please be seated, everyone. All right, anybody need to talk about anything on the record before we just talk about off-the-record contact information type stuff? Anything from the state?
No, Your Honor.
Anything from the defense?
No, Judge.
Okay. All right, off the record, let's just talk about going forward. We will find out what time they're coming back and we'll notify you by email. We had previously discussed, Mr. Victor asked, could he be at his office, understanding it's probably at least 35 minutes away, and the answer is yes, because it's going to take a while to get everything together, so I'm okay with that. If there is a question starting tomorrow, you need to make sure you're immediately available, either everyone who's going to participate or the designee between the parties, so I can get you on the phone right away and discuss a question. We can talk about an answer. I don't want there to be a lag, so make sure we have good contact information for you going forward. Trying to think if there's anything else we need to cover in terms of just the logistics of the jury coming back with a verdict. Make sure you've got a laptop available for tomorrow. Do you already have one set up? Okay, we'll provide it, make sure it's there. Make sure it doesn't have any secret messages like guilty, guilty, guilty on a screen when they pull it up. I'm trusting that that's the case going forward. And I don't think there's anything else. Any questions about what we're doing? Ms. Johnson, what will happen is once we figure out, we get word there's a verdict, we'll get you dressed out so you're here. We'll take the time necessary to do that, to get you ready like it would be a regular day for trial before we bring the jury back in. Now I knew I was forgetting something. If we have an aggravation phase, if the jury comes back guilty, then we go into another phase, which is the aggravation phase. The state has alleged specific aggravating circumstances. I took the state's filing from way back when and looked at it and added the dangerous crimes against children and eliminated one and part of one. The one I eliminated was the capital, heinous, cruel, and depraved aggravator that was finding its way into some of the state's filings, which would be okay for a capital case, but not here. There may be one other. We'll kick a draft out tomorrow morning and probably email it to you so we can have some discussion and make sure we've got the appropriate jury instructions. I want to get them finalized so if the jury comes back with a guilty verdict or guilty verdicts, we're going to flip right into an aggravation phase right away. Is the state planning on doing anything other than arguing in an aggravation phase?
Yeah, we haven't decided that yet.
Okay. Let me know soon because I need to get an idea of time. It may be if the jury comes back with a verdict, let's say at 3:30 or 4, and it's guilty, I may send them home and tell them to come back the next day so we can get set up and we're not pushing into 5 o'clock. Would you have any intent to present any witnesses and do anything other than argument in an aggravation phase?
We haven't decided, Judge.
Okay. Well, we've got the no decide, no decide. I don't have a whole lot of guidance, but we'll deal with that. I want a little more certainty as we get close so I know what I'm dealing with. If the jury comes back before, say, 2:30, then I'll probably kick it right into the aggravation phase. We'll pass out the instructions and we'll go at that point.
Judge, I think we can assume there's going to be an aggravation phase because I'd be very surprised if they came back with a not guilty on custodial interference.
You would be, and I would be too, but we've all seen things that surprise us. I understand what you told the jury, so I'm assuming we're going to have some sort of aggravation phase. The aggravators apply to each of the counts, so we would almost certainly come back, and that's obviously likely to happen. All right, then we'll be in touch in terms of the jury schedule, and tomorrow What I'd like you to do is starting after 10:30, and Katie may be able to email the jury instructions to you before. I think she was doing a draft for me to look at. I may be able to flip them around tomorrow morning, and while I'm going through my morning calendar between 8:30 and presumably around 10:30, maybe she'll be able to get them out, or maybe it'll be shortly thereafter. And then we'll get you on a conference call. We may make a record right there in terms of any objections. Typically, the aggravation instructions aren't particularly complicated. I'm including the definition of dangerous crimes against children. There's not a whole lot else in terms of definitions that need to be in there, I don't think. So if you have any suggestions you're thinking about tonight, feel free to send it to everybody. All right? All right, I'll see everybody either tomorrow or the next day or whenever the jury comes back. Let the record reflect the presence of the jury panel, the defendant, and counsel. Ladies and gentlemen, welcome back. Have you reached your verdicts? Would the foreperson please hand the verdict forms to the bailiff?
State of Arizona versus Elizabeth Johnson, CR 2010-101-760-001. Verdict as to count 1 kidnapping. The verdict form is blank. Verdict as to count 1, lesser included. Having found the defendant not guilty of kidnapping, or, after full and careful consideration of the facts, being unable to agree on whether to find the defendant guilty or not guilty of kidnapping, we, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant, Elizabeth Johnson, as to the offense of unlawful imprisonment, guilty. We further find that this offense is a domestic violence offense. Was the victim released voluntarily by the defendant without physical injury in a safe place prior to arrest? No. Signed, foreperson. Verdict as to count 2. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant, Elizabeth Johnson, as to the offense of conspiracy to commit custodial interference, guilty. We further find the defendant was the child's parent. We further find the child was taken, enticed, or kept out of state. We further find the child was not voluntarily returned without physical injury prior to arrest or the issuance of an arrest warrant. We further find that this offense is a domestic violence offense. Signed, foreperson. Verdict as to count 3. We, the jury, duly impaneled and sworn in the above entitled action upon our oaths, do find the defendant, Elizabeth Johnson, as to the offense of custodial interference, guilty. We further find the defendant was the child's parent. We further find the child was taken, enticed, or kept out of state. We further find the child was not voluntarily returned without physical injury prior to arrest or the issuance of an arrest warrant. We further find that this offense is a domestic violence offense. Signed, foreperson. Are these your true verdicts, so say you one and all?
Yes. Does anyone wish to poll the jury? Okay, ladies and gentlemen, what we're going to do is we're going to go through now individually with you by number, and the clerk is going to ask you if these are your true verdicts individually, starting with juror number 1 and going down the line. So we'll start with juror number 1. Go ahead.
Juror number 1, are these your true verdicts?
Yes.
Juror number 2, are these your true verdicts?
Yes.
Juror number 3, are these your true verdicts?
Yes.
Juror number 4, are these your true verdicts?
Yes.
Juror number 6, are these your true verdicts?
Yes.
Juror number 7, are these your true verdicts?
Yes.
Juror number 10, are these your true verdicts?
Yes.
Juror number 11, are these your true verdicts?
Yes.
Juror number 12, are these your true verdicts?
Yes.
Juror number 13, are these your true verdicts?
Yes.
Juror number 14, are these your true verdicts?
Yes.
Juror number 15, are these your true verdicts?
Yes. Thank you. Okay, ladies and gentlemen, we have one more thing remaining to do. One of the instructions I gave you was that you are not to focus on or think about punishment. Punishment is left to the judge. But there is one thing that Arizona law requires you to do. When I sentence someone, I consider certain aggravating circumstances when I decide what the sentence is going to be. In other words, I give weight to any aggravating circumstances that exist. It is the law that it's the jury's job to determine whether certain aggravating circumstances actually exist. So what we are going to do right now, we're going to have some brief evidence and argument to you, and you're actually going to get another short set of instructions that I'm giving to Kim right now that I'm going to read to you. They're much shorter than the other instructions. And you're going to get verdict forms. What's going to happen is we're going to have, I think, one witness that's going to testify in this phase. The witness will come up and testify. There'll be brief argument from both sides, and then you'll go back and deliberate on the aggravating circumstances that are alleged. So that's what's going to happen. We're not quite there yet. So Kim's going to pass out these instructions to you. Okay. And since I'm going to read verbatim, are we okay with the court reporter not taking down what I'm saying? Are we okay with that?
Yeah, sure.
Okay. All right. Ladies and gentlemen, the defendant has been found guilty of unlawful imprisonment, custodial interference, and conspiracy to commit custodial interference. Under Arizona law, every person guilty of this crime is presumed to be sentenced to a presumptive sentence. That sentence may be increased by the sentencing judge if aggravating factors are proven by the state. The law requires that you now determine whether the state has proved any of the following aggravating circumstances beyond a reasonable doubt. These findings will be considered by the court in determining the sentence to be imposed on the defendant. Aggravating circumstances alleged. Number one, the offenses involve the presence of an accomplice, and this is for custodial interference only. That is the custodial interference only count. Number two, the offenses cause physical, emotional, or financial harm to the victim. In deciding these issues, you must determine from the evidence presented whether the state has proven each of these allegations beyond a reasonable doubt. The jury instructions previously given also apply where relevant, including the definition of reasonable doubt and the requirement that each aggravating circumstance finding be unanimous. The defendant is not required to testify or produce evidence of any kind. The decision on whether to testify or produce evidence is left to the defendant, acting with the advice of an attorney. The defendant's decision not to testify or produce evidence is not evidence of the existence of any aggravating circumstance. You must decide each aggravating factor separately on the evidence with the law applicable to it, uninfluenced by your decision on any other aggravating factor. You may find that the state has proved beyond a reasonable doubt all, some, or none of the aggravating factors. Your finding for each aggravating factor must be stated in a separate answer. During your deliberations, you were able to discuss the case with each other in the jury room. During this phase of the trial, you may again not discuss the case with each other until all of the evidence for this phase has been presented. You've been given instructions and heard closing arguments for this phase of the trial. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and all of the instructions I will give you on the law. Keep an open mind. Form your final opinions only after you've had an opportunity to discuss the case with each other in the jury room at the end of this phase of the trial. All 12 of you must agree on a verdict. If you cannot unanimously agree on whether an aggravating circumstance exists, please so indicate on the verdict. Your foreperson will be in charge during your deliberations and will sign any verdict. Okay, I'll go over the verdict forms with you after we hear the evidence. And the state, of course, has the burden of proof, and I believe the state is going to present a witness, so the state may call its witness.
The state calls Frank McQuarrie.
Mr. McQuarrie, come on up. We're going to swear you in again because we're in a different phase of the trial. So come on up. Julie's going to swear you in, I think.
Hi. Can you state your name and spell your last name, please?
Franklin Scott McQuarrie, McQuarry.
Thank you. Raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Come on around.
All set?
Go.
Okay. Mr. McQuarrie, I know you already testified in front of the jury, but just as a brief introduction, you are the father of Logan McQuarrie, correct?
Yes.
And the grandfather of Gabriel Johnson.
Yes.
All right. Now, in your capacity or in your role as father and grandfather, were you able to observe Logan interact with Gabriel?
Yes, I was.
And was that throughout his entire 7 months of life?
Yes.
Were you also able to observe the interaction between Logan, Elizabeth Johnson, and Gabriel Johnson as well.
Yes.
Now, would you say that there was a bond formed between your son and your grandson?
Most definitely.
And could you describe the bond that you observed?
Gabriel was Daddy's boy. When Logan was around, he wanted Daddy to hold him. He wanted Daddy to play with him. Daddy was his world.
And obviously, Gabriel was at a very young age, so what observations did you note that led you to form your opinion as to the bond between the two?
If he was crying, Logan picked him up. He'd quit crying. If Logan would play with him, he'd laugh. He wanted Daddy. If I held him and I'd play with him, get him to smile a little bit or something, Logan come around, he wanted Daddy back.
And when you observed the three interact, Elizabeth, Logan, and Gabriel Johnson, could you describe your observations there?
Sure. Like I said, he was definitely Daddy's boy. He didn't want a lot to do with Elizabeth. If Elizabeth was holding him and Logan was there, he wanted Logan.
And what led you to make that opinion?
Well, he would reach out for Logan. If Elizabeth held him and Logan was there, he didn't want Mom to hold him. He wanted Daddy to hold him.
Right, now obviously, we've already heard testimony about the fact that Logan came to live with you in December of 2009 after he ended his relationship with Elizabeth. Is that correct?
Yes.
And prior to that time, obviously, you've had a lot of contact with your son throughout his whole life. Is that
Yes.
a fair statement? What changes did you see in him after he no longer saw his son any longer?
He started losing weight. I'd wake up at 2, 3 o'clock in the morning. He'd be up. And I would be talking to him, telling him, you've got to get some sleep somehow. He's pale, tired. He started smoking more. He was constantly on the computer, on the telephone, trying to find where that baby was.
And did you ever observe, well, you stated that you would get up at 2 or 3 in the morning and see him. Where would he be?
He'd be outside, sitting by himself. Sometimes he'd be crying a little bit.
And you indicated that he started smoking more
Oh, yes.
and losing weight.
Yes.
And was that unusual for your son?
Yeah, he was always thin, but he was becoming very much more so.
Now, you were also present when the first media release was done on this case. Is that correct?
Yes.
And as part of that media release, Logan had to make a statement, correct?
Yes.
Could you describe what you observed about Logan when he had to make that statement?
He was terrified. He's shy. He's not very outgoing. It was one of the hardest things that I have seen him actually do in his life. And he did that for his son. He wouldn't have done it for anything else.
And in fact, after Gabriel went missing, Logan actually left the state at some point and went to Texas. Is that correct?
Yes, it is.
And why did he go there?
He wanted to follow behind every place that Elizabeth had gone and find anything that he could, any little scrap of information that might lead him to Gabriel.
Did that cause him to have to leave his job here?
Yes.
And did that cause him financial loss?
Yes.
And Mr. McQuarrie, Logan no longer lives in the state of Arizona, correct?
That's correct.
He has a job in another state now?
Yes.
And he was unable to be here today, correct?
He's a long way from here, yes.
Thank you. I have no further questions.
Thank you. Any cross-examination?
No question.
Any questions from the jury for Mr. McQuarrie before we let him step down? Doesn't look like it. Mr. McQuarrie may step down. Thank you. Does the state have any other witnesses it would like to call?
No, Your Honor.
Does the state rest?
Yes.
Does the defense have any evidence it would like to put on in this phase?
No, Judge.
Okay, so that we're going to go into closing arguments in this phase of the proceeding. The state gets to go first, so the state may proceed.
Thank you, Your Honor. Good afternoon. You probably are sitting there feeling like you've been tricked. We send you away 2 days ago, give you a bunch of forms and ask you to fill them out, ask you a bunch of questions, and you come back and you probably think you get to go home today. But I promise you, we originally told you you'd be in this trial until November 6th. I promise you I'm not going to keep you here till November 6th. It'll be pretty short today, and hopefully you'll get to go home today. But we do want you to consider the information the judge has just told you about the aggravating factors in this case. And certainly you've heard the testimony throughout the trial. And you don't only have to consider what you've heard just this afternoon, but you can consider anything you've heard throughout this entire trial that goes into the aggravating factors that we have alleged in this case. But I want to start with the emotional harm to Gabriel Johnson. Now, Gabriel Johnson is clearly the victim of the unlawful imprisonment count that you found the defendant guilty of. And the reason we had Mr. McQuarrie, Frank McQuarrie, talk about the bond that Gabriel Johnson had with his father is I want you to think about what Gabriel was going through during the entire process of this case. On December 9th, 2009, Elizabeth Johnson, his mother, gave him away to strangers. And they were very nice to him. They took him to see Santa Claus. They had a little girl who played with him. But they were still strangers to him. Gabriel Johnson had a bond with his father, a person he wanted to be held by, a person he wanted to play with, a person who would make him laugh and smile more than anybody else. And yet on December 9th, he was given away to strangers whom he lived with from the 9th until the 18th of 2009. And the whole time, he's probably wondering, where's my family? As much as a 7-month-old child can wonder that, he's probably wondering, where's my daddy? Where's the person I want to be with? And on December 18th, 2009, his mother took him out of the state into a strange hotel room, into a car, and had him there. And you can see from the pictures that were introduced into evidence that he wasn't without items and without toys, but what he was without is his father, is his cousins, his aunts, his grandfather, the people who loved him and cared for him and saw him every day. Remember, you heard from the testimony from Logan and Elizabeth's neighbors about how they would watch Logan take care of Gabriel and the interactions. And so there is this child who, we've talked about how Logan has never seen his son since December 8th, but Gabriel has not seen his father or the rest of his family, the rest of Logan's family, since December 8th, 2009. So clearly that child has suffered emotional harm for what Elizabeth Johnson did to him. Now, you also found the defendant guilty of both custodial interference and conspiracy to commit custodial interference. Now, clearly, the fact that Logan has not seen his son since December 8, 2009 has affected him. You've seen that from Logan when he testified. Now, he's certainly talked about this case many more times, long before he ever got before you. He told the police several times. He talked to the police. He talked to the prosecution. He's told the story to the media, and then he had to come and tell you. It's not the first time he said it. But he's emotionally charged from this case. He searched for his son. He went to San Antonio and followed every single step that Elizabeth Johnson and Gabriel Johnson took to see if he could find out what happened. So certainly, there's absolutely no question that Logan suffered emotional harm in this case. And we've also alleged in the custodial interference that there was an accomplice. The accomplice in that case was Tammy Smith. You could probably even consider Jack Smith as a possible accomplice as well. Obviously, you found them guilty of the conspiracy to commit custodial interference, but certainly the actions that they took resulted in the actual custodial interference. So Tammy Smith's actions in assisting Elizabeth to try and go to Tennessee, and assisting Elizabeth to try and interfere with Logan's rights, there was an accomplice there helping Elizabeth along doing that. So I'm confident that after you've heard the evidence in the trial and the evidence that you heard that we presented today, you'll have no problems coming back, finding all of the aggravating factors we've alleged in this case. Thank you.
Thank you. On behalf of the defendant, Ms. Clark.
Hello, ladies and gentlemen. Everyone here has had a chance to talk to you. This is my first time, so I want to thank you, first of all, for your time here and the amount of time you spent listening to everything we had to present, and for the time that you spent deliberating over everything and coming to the conclusion that you came to. We at the defense team, we've made a sincere effort not to waste your time. We've made a sincere effort not to just throw out any type of defense to you. We've come at you with what we feel is honest, what we feel is supported by the facts, what's supported by the law, and what's supported by the evidence that you've seen. I'm not going to do anything different here. That's why we're not going to dispute the enhancement or the aggravator regarding emotional harm. It would be silly for me to stand up here and argue to you that there's no emotional harm to any of the victims here. Obviously, there's emotional harm. There's a child without a father. There's a father without a child. There's no argument that there's not emotional harm. That's clear. The only thing I have for you to think about is in regards to whether or not there was an accomplice in the custodial interference. And what that hangs on is whether or not you find that the conspiracy, and not just that you find, but that the state proved beyond a reasonable doubt that the conspiracy continued past the 20th. Past the 20th of December 2009, before that, there was no custodial interference. So in order to find the presence of an accomplice, you must find that the conspiracy continued past that date. I ask you to look back at the evidence that the state presented for the conspiracy charge. They presented evidence that Elizabeth and Tammy were working together. We conceded that to you in closing argument. However, the only evidence of any type of interaction after Elizabeth left the state, other than phone calls between Tammy and Elizabeth that we don't have any idea of what the content was, is a bunch of text messages and MySpace messages of Tammy trying to get Elizabeth to come back, clearly indicating that she's not on board with what Elizabeth is doing at this point in time. Tammy working with Logan, trying to get Logan to cooperate with her so that she can bring Elizabeth back. Again, evidence that they're not working together at this point in time. The evidence that there might have been some possible working together at this point, maybe after the 20th, is the GPS device that had Tennessee in it. We don't know when that was put in there. You heard testimony that we can't tell because of that device when that location was actually put in there. Could have been put in prior to the 18th, could have been put in after the 18th, could have been put in after the 20th. We don't know. Because we don't know, I submit to you that that's not enough to overcome reasonable doubt. Outside of that, the only other piece of evidence that you have is a phone call. A phone call to an individual in Tennessee who could give legal advice. We don't know what legal advice that is. We don't know if the legal advice that Tammy Smith was trying to get out of Janet Morris in Tennessee to Elizabeth was, come back. You're not listening to what I told you. We have no evidence of that. The state did not present any evidence of the content of that phone call. Again, the question here is, have they proved it beyond a reasonable doubt? Just because we're past the stage of guilty or not guilty and just dealing with aggravators doesn't mean their burden has lessened. Their burden is still the same that it was before. And you need to come back with the thing within mind that is one phone call where we don't know what was said enough to prove beyond a reasonable doubt that the conspiracy continued past December 20th, 2009? Is that what we consider enough evidence? I submit to you that it's not. And I think, and I'm confident that you can come back and agree with me that on this point, the state has failed to meet their burden. And for that reason, that aggravator doesn't apply here. Thank you.
Thank you. Rebuttal, Ms. Andrews.
Yes, thank you, Your Honor. I don't think I'll disagree with defense counsel when she says the custodial interference didn't occur until December 20th, 2009. Certainly, we presented evidence that the plan between Tammy Smith and Elizabeth Johnson occurred before then. But in fact, Logan was not supposed to have Gabriel until December 20th, 2009. But I can agree that we didn't present any evidence that there was an accomplice after that date because we presented numerous pieces of evidence that there was. In fact, the GPS, as Ms. Clark mentioned, that was in Elizabeth Johnson's possession that had a Tennessee address in it, is only one piece of evidence. The other piece of evidence we have is the fact that Tammy Smith asked for Janet Morris's phone number in Tennessee December 24th, 2009. We have the fact that Elizabeth Johnson talked to Janet Morris in Tennessee on December 26, 2009. We have the fact that Logan did not start speaking to Tammy and Jack Smith until December 22nd, 2009. And after that date, we have both a phone call and a text message where they told him, you need to sign adoption paperwork so that Elizabeth will come back, Gabriel will be with us. So they essentially told him, unless you sign adoption paperwork so Gabriel's with us, you're not ever going to see your son again. That is certainly custodial interference. We also have the evidence that in the confrontation call where you heard Elizabeth tell Tammy, you told me to go to a shelter and say I'm being beat. You told me that. That was your idea. And then we have Elizabeth in Miami Beach on December 30th, 2009, telling the detective that very thing. So certainly we've presented ample evidence that the custodial interference certainly occurred and that there was an accomplice to the custodial interference after December 20th, 2009, and therefore there was an accomplice on that particular charge.
Thank you, Ms. Andrews. Okay, the instructions say that you'll be given 4 forms of verdict. You're actually going to be given 3. I put the wrong number in there. So you're going to be given 3 forms of verdict, and they read as follows. They're a little different than what you got before. They have the caption, and as to count 1, it says, we, the jury, impaneled and sworn in the above entitled cause, do upon our oaths as to count 1, the lesser included of unlawful imprisonment, unanimously find beyond a reasonable doubt the following aggravating circumstance or circumstances as shown by the circumstance or circumstances checked. And then it lists the aggravating factor, which for count 1, there's only one. The offenses cause physical, emotional, or financial harm to the victim. And you check either proven or not proven. And the foreperson signs it. The second form goes to count 2. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths as to count 2, conspiracy to commit custodial interference, unanimously find beyond a reasonable doubt. It lists the aggravating factor. In this one, again, the offenses cause physical, emotional, or financial harm to the victim, proven, not proven. The third looks very similar. Count 3, and that relates to custodial interference, and it says, we, the jury, duly impaneled and sworn in the above entitled cause, do upon our oaths as to count 3, custodial interference, unanimously find beyond a reasonable doubt the following aggravating circumstance or circumstances as shown by the circumstance or circumstances checked. This one's got 2 possible aggravating circumstances. It's the offense involved the presence of an accomplice, and the offenses cause physical, emotional, or financial harm to the victim. Again, you check proven or not proven. And that's it. And you fill them out. And so I'm going to send them back with you. You can go back and deliberate. And when you are finished, we'll be here for you. So Kim will bring them back. And we'll see you when you have your verdict on. Okay, please be seated, everyone. In my experience, this phase does not take very long. And based on the argument I heard, I would expect the jury to come back today, and so I don't want anybody who needs to be here, meaning the attorneys, the parties, to go anywhere, because I expect that the jury will be back soon. So it's very clear. The clerk reading the first verdict as a kidnapping being blank means that the jury was unable to reach a verdict as to the kidnapping charge. And they were instructed, if that was the case, to go to the lesser included for count 1, which was unlawful imprisonment. And they found Ms. Johnson guilty of that offense. So that's what happened, and that's why there was a blank form as to count 1. Okay, so as soon as the jury's back, we're going to come back. Anything from the attorneys? Mr. Victor.
Yes, Judge. Judge, based on the jury's verdict, I think that the landscape of this case is now dramatically different than it has been since the beginning. My client now has been in jail approaching 3 years. She has a $1 million cash-only bond. I think as of this moment, that bond is unconstitutional. I have a motion. May I approach?
You may. Mr. Victor has given me a motion to modify release conditions, setting forth obviously an argument to modify Ms. Johnson's release conditions. I will tell you that I want to give the state an opportunity to respond. I'm not going to make a change today. I will, and as part of the process, I'm going to be scheduling a hearing either next week or the week after to discuss sentencing issues, and at that point I will consider a motion to modify release conditions. But I want to give the state an opportunity to respond in writing on this issue, so there won't be a modification today for the release conditions.
Judge, I understand the court's position. I also understand that the rule allows the state 10 days to respond. However, given the unique circumstances of this case, given the fact that my client has now been in custody approaching 3 years now, given that this court is very well acquainted, having been through the Tammy Smith trial, having now been through this trial, this court, it's hard to imagine how any court could be better acquainted with the facts of the case than you are right now, Judge. Given all that, I would ask the court to reconsider its ruling and maybe take a break to give the state an opportunity to read through the motion, think about what their position is. But I think that at this point, Judge, we know one thing for sure. $1 million cash only is not the least onerous bond. And so it needs to change at this point. And I'd ask the court to reconsider that and make a change today. If not, I'd ask the court to set a hearing for tomorrow.
Both requests are denied. I'm not going to consider it today. I'm not going to consider it tomorrow. I'm going to give the state an opportunity to respond. So we'll set a date when the jury comes back in this phase for when we will talk about release conditions, and we'll also talk about sentencing, because as I told the lawyers when I talked to them earlier, with respect to sentencing, I'm going to want to have a status conference so we can make sure there's agreement on the sentencing range and other issues relating to sentencing going forward before we have an actual sentencing proceeding. So I'll take it up at that time, but I'm not going to reconsider it today, and I'm not going to reconsider it tomorrow.
Judge, I'd ask that the hearing be set at least no later than 10 days from today, given that that's the ordinary period of time that the state would have. And frankly, I think it ought to be set a little bit sooner, so we'd ask for the earliest possible setting.
I understand your position, and I'll set it after the jury comes back from the aggravation phase.
Okay, Judge.
Ms. Andrews, anything from your perspective?
No, thank you, Your Honor.
Okay, all right. So as soon as the jury comes back, be ready to go. As soon as we hear from them, I'm going to stay down here, and I'll be ready to come out, and I expect it to be in the next few minutes, so I'll see you in a few minutes. Let the record reflect the presence of the jury panel, the defendant, and counsel. Ladies and gentlemen, have you reached verdicts in the aggravation phase? Yes. Okay, the foreperson will hand the verdict forms to the bailiff. Thank you. And the clerk will read the verdict forms.
State of Arizona versus Elizabeth Johnson, CR 2010-101-760-001. Aggravation verdict as to count 1. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths as to count 1, lesser included unlawful imprisonment, unanimously find beyond a reasonable doubt the following aggravating circumstance or circumstances as shown by the circumstance or circumstances checked. The offense caused physical, emotional, or financial harm to the victim. Proven. Signed foreperson. As to count 2, we, the jury, impaneled and sworn in the above entitled cause, do upon our oaths as to count 2, conspiracy to commit custodial interference, unanimously find beyond a reasonable doubt the following aggravating circumstance or circumstances as shown by the circumstance or circumstances checked. The offense caused physical, emotional, or financial harm to the victim. Proven. Signed foreperson. As to count 3, we, the jury, impaneled and sworn in the above entitled cause, do upon our oaths as to count 3, custodial interference, unanimously find beyond a reasonable doubt the following aggravating circumstance or circumstances as shown by the circumstance or circumstances checked. The offense involved the presence of an accomplice. Proven. The offense caused physical, emotional, or financial harm to the victim. Proven. Signed foreperson. Are these your true verdicts, so say you one and all?
Yes. Would anyone like to poll the jury?
No, Judge.
Okay. All right. So, ladies